Um, and then these channels as well will be for giving feedback to the company. Again, because you're trying to, I know going to work can be daunting, but you don't have to. It's possible to make your working conditions better. So if you have a channel that allows for your time at work to be at least more bearable, that's what you want. You don't need to cry every morning when you wake up. And then grievance and dispute resolution. Again, we want another channel a secure channel where someone can be able to raise a problem or raise a concern, and that it will be addressed in a timely, impartial, and confidential manner. Clause 10 is on tracking. Now, I understand that for some of these jobs, a lot of these jobs, if I'm not mistaken, there are tracking tools that are used to monitor your performance. But now the practice has been that they collect too much information and they're too intrusive. So we'd want them to limit how much information is collected and only to limit how much information is collected, to only what is necessary for your performance. And then there also needs to be disclosure of exactly what will be collected. And even in its collection, one of the data protection principles that exist is one of proportionality and data minimization. So we need to make sure that whatever they only collect information that is limited to what they need, and it has to really just be what they need. And then another principle has to do with the storage of data. Data has to be stored in a very responsible way, so we also need them to be upfront about how it will be stored and how long it will be kept for. And I mean, in line with that is just comply with our Data Protection Act as well as the GDPR. We have confidentiality. The duty will be borne by both the worker and the company. Intellectual property, we are saying that any tools or materials that the worker brings into the engagement will be theirs, but what is developed during the pendency of the engagement will be owned by the company, because this is standard practice wherever you go to work. On the non-compete clause, we are asking that the worker not be restricted from seeking or accepting other work unless there is a direct conflict of interest. And what this non-compete will also demand from the worker is a duty of disclosure. So you'll need to disclose to the company if you get an agreement, rather if you get another engagement that competes with duration, termination, governing laws. The rest are pretty standard. We're asking them to expressly resign themselves or surrender themselves to the laws of Kenya. That is what will govern the agreement, and any disputes that arise from here, from the agreement, shall be determined in Kenyan courts. Now, what I need to again re-emphasize about this contract is the fact that much as we are using this opportunity as one to have our demands heard and at least made more visible, it raises duties on both sides, on both parties. So, and it's important to ensure that even as the worker, you're able to meet all the duties that are expected of you. Confidentiality, meeting your deadlines, doing your work well, rendering the services that you have said you will render, and hopefully it is with that, the mutual performance of your duties that will allow, this contract to be successful and to yield the results that we hope that it will yield. So yes, that is the contract that we'll be proposing. If you have any questions or any comments, feel free to raise them now. This is why we called you here, so that you can tell us if kama tumeuma nje, if we have beaten outside, or if the concerns have been properly reflected, or if there's anything that has been missed.
document, you refer to the worker as a worker rather than independent contractor. Did you choose that rather than employee? And then also, you didn't have a definition for the employer. Was that purposeful, or what's your thinking around that?
So yes, it was very intentional that we go with worker as opposed to independent contractor or employee, because the threshold for being an employee is rather high, and a lot of workers under such engagements don't meet it. It's very different, and we chose worker because we felt like it fell in between an independent contractor and an employee. If you were to approach this contract by referring to the worker as an employee, outrightly the companies would refuse to assent to it. They'd refuse to agree to it. So that was also part of the thinking that went into it. And then on the description or the definition of the company, I think we have it here as, it's in the first paragraph, but it's either the company, organization, or platform. And I think that was just a clarity issue that we can fix later. But we were basically referring to the BPOs, the business process outsourcing firms, as well as the platforms, because those are the two main areas where data workers are found.
How do you want to refer to them?
The company. Just the company. Just the company, but another term we were thinking of, it will depend on the specific contract, but another term we were thinking of was the contracting entity for now, because it's more general. Yes. Do you have any suggestions?
No. Oh. Thinking out loud.
Okay.
But is there a definition for worker in our laws?
No. Okay. It's just employee. Our laws only provide for employee. Yes.
It's not an easy one. I'm just curious.
Yeah. It's really not an easy one. And there have been, in certain jurisdictions, I've come across cases where platform workers have managed to be classified, to get the classification of employee. But then again, unfortunately, those cases are usually for the location-based platform workers, basically taxi drivers, delivery people. It's easier for them, but now for data workers, it becomes a bit more complicated. Yeah.
Maybe first, and thank you very much. This is quite ideal. And the beautiful thing about this is that it's really embedded in the principles of the Constitution rather than our labor laws. So I find it quite progressive. And as the discussion that you are having about a worker, an employee, our Constitution is very clear in terms of the rights that are supposed to be enjoyed by everyone. And then it becomes very specific in terms of every worker. So the Constitution actually talks about worker. It doesn't talk about employee. And then the reality is that our labor laws have never really been in a position to catch up with the Constitution. So we have a very progressive Constitution, but not quite progressive labor laws. And I think because these laws were enacted in 2007 while the Constitution was enacted in 2010, but I thank the creators of the Constitution because they foresaw such kind of issues where fundamental rights are only guaranteed for a certain section of workers. And I think even at the international level, the discussions are around how do we ensure that all workers have access to fundamental rights and freedoms at work, because that is even the reality when it comes to the informal economy, and trying to navigate through that process within very limited labor laws, which just think about the first industrial revolution, then becomes quite difficult. But I like the way you've crafted it. My question was on whether you thought around, and I know this should be the automatic case where non-disclosure agreement should not necessarily be waive or become an illegality in itself. So it waives the rights of workers. So where you cannot exercise some certain laws, or some certain rights. So I'm wondering whether it would be important for you to consider ensuring that somewhere in the clauses around the NDI, that any NDI that is signed should not waiver any constitutionally mandated rights. So that brings an issue of first empowering the worker, knowing that as much as I'm signing an NDI, this does not necessarily limit me from exercising the rights as provided by the Constitution. So I felt that maybe you could have such kind of a clause just to strengthen the NDI part, because as much as NDI should not waive rights, most of the time they do. So how do you also empower, but also make sure that the contract is very clear on that issue?
Yeah, thank you. Thank you for that feedback. It actually had not occurred to me that NDAs could actually can be used to supersede the terms of this agreement, but yes, we'll take that into consideration, because I think, again, that's where a lot of companies get away with a lot, and we had it earlier that from Kauna's experience, before she decided to join the Meta case, she kept going back and forth on it because of the NDA. So yeah, we'll check it. We'll look into that. Thank you. Yeah.
1 minute. I have a question for you. So whatever we have shared is a model. It's like a draft zero because we are just workers and we wanted stakeholders to be on board so that we can build on it. So the question about the definition of employer, are we supposed to, is it necessary we include it, or do we just, yeah.
Yes. I'm sure there'll be lots of, I guess, yeah, I'm sure, I think this is a really important conversation that we've been having for some time, and there's some of us that really want to push this, there's some of us that really want to push this definition of employer. Obviously, it presents really difficult challenges around the world in different contexts. And also, we want to kind of have a global strategy because these companies are global and they're only going to look at implementing structures that can work across boundaries. So without taking too much time, I think that that's something that we need to discuss further, right? Yeah.
I want to make maybe perhaps comment on on what you've presented. Is it what needs to be signed by the employer and employee? Okay, it's a model which I accept. Huh?
Yes.
However, having worked, let me say, in another cape, having worked with a union before, and how this would work, the union that I work represents journalists in Kenya. How it works, no one contract is similar to the other company. They're very different. And my proposal will be, even from how the conversations began in the morning, if it was from a union approach, I would call it a model for a collective bargain agreement. That's how I could rate it, the way you've just presented it. Like a model on how you can collectively perhaps go to TikTok, Google, Microsoft, FB, and the rest as a model. Like, this is what we would prefer for our members. Because how you agree on each, because it's always like you are buying in. And then the company will share their own views, then you see if it's agreeable, because you still hold more of the cards than the company itself, because you want the best for the people whom you would want to represent. So for me, I look at it as a model for a CBA, not as a contract between an employer and employee. They will definitely, because if it's in that particular approach, it will not be ideally accepted. Just being very frank, looking at even how the legal lawyer at the Union of Journalists has been working and negotiating with the various media houses.